It is our mandate as MARC Research Associates to do public education, and this is the first of this school year's series, and we invited Justice Carbullido a year ago. And what was not clear was what Justice Carbullido's title was, but we wanted him to speak on the condition of the courts. And as you see behind me, that's the title of tonight's speech, and I think that all of us are excited. An independent judiciary for an independent Guam, exploring the establishment of a judicial branch under a new political status. Ladies and gentlemen, Associate Justice F. Philip Carbullido.
I want to thank Arlene Steffi and the MARC Seminar Series for inviting me here this evening. I also want to thank everyone in the audience in attendance. I attended President Underwood's presentation last Tuesday, and he's a pretty popular guy on this campus. And so he just really packed this room. I was very concerned. I was telling my wife over the week, especially with the weather forecast, it was supposed to be torrential rain, more than my family and my judicial family will be present tonight. So I am very grateful. I want to thank you for being present tonight. As Arlene mentioned, she invited me to speak at the seminar series more than a year ago. And, true to form, when I asked, well, what do you want me to talk about? And she said, anything. Well, that's the worst kind of invitation a speaker can receive. And so really, I started seriously thinking about this about 6 months ago. And as Arlene mentioned, she wanted me to talk about the courts. That's something I can easily do. But I wanted to select a topic that was relevant, that was interesting, hopefully, and that would be informative in reference to events that is occurring here on our island. I thought about two important events that suggest the topic of what I want to discuss with you this evening. One was that we are celebrating this year, continue to celebrate the 75th anniversary of our Liberation Day, our liberation from Japanese forces from World War II. And also, we continue to have in the forefront for discussion our political status, the quest for self-determination, Guam's quest to determine its political status with the United States. That continues to be on the forefront of our public discussion. And especially with the Davis case that just recently came out, I wanted to try and speak to in the context of these two events that I felt was relevant. Well, if I was to select statehood or free association, I think my discussion would be very predictable. We are, as in terms of statehood and free association with the United States, any discussion in reference to our political status would be couched in terms of the judiciary being a co-equal branch of government and it acts as a check and balance in reference to our other two branches of government. And so I wouldn't be able to hold your attention. And so I thought, what about independence? If the people of Guam were to elect the status of independence, how would the judiciary be established and be founded under an independent nation of Guam? I quite frankly didn't know the answer to that. And so I started exploring, thinking about it, and that if you in the room were tasked to be our delegates to write our Constitution after the people of Guam hypothetically were to select an independent status, what are some of the concerns, considerations you should take into account in establishing a judiciary that the people of Guam would be proud of? and would entrust. And so it's within that context that I offer you my thoughts, my suggestions in terms of thinking about the issues. Now, I must make a disclaimer. I sit on the judiciary. There are rules of ethics that apply to me and my colleagues. And so I'm not advocating for any particular self-determination, political status position. But what I can offer within the restrictions of our Code of Judicial Ethics is that we can be part of the education process. So I intend to, and I would like to, be part of that education process so that we can be more informed in trying to obtain the best possible status and whatever that requires, in reference in particular tonight to the judiciary, that we can do for the people of Guam. So with that context, I would like to start my presentation. This year marks 75 years since the armed forces of the United States stormed the beaches of our island and reclaimed Guam from the Japanese military who had occupied Guam during World War II. The commemoration of the 75th Liberation Day presents an opportunity for us to think about the meaning of the word liberation, release or freedom from oppression. In the historical and most obvious sense, we can think about Guam's liberation from foreign forces. But I suspect that a few in this room, probably more than a few in this room, might ask, has Guam truly been liberated? This question is perhaps especially timely, given the recent Ninth Circuit ruling in Davis versus Guam. Arnold Dave Davis had challenged Guam's political status, plebiscite law, which allowed only native inhabitants of Guam to express a choice on 3 political status options: independence, free association, or statehood. Davis, a resident of Guam who did not fulfill the definition of native inhabitant of Guam, filed suit arguing the plebiscite law was a race-based classification that infringed on his constitutionally protected right to vote. The 15th Amendment to the United States Constitution provides that the rights of citizens of the United States to vote shall not be denied or abridged on account of race. The issue in the Davis case was whether the 2000 plebiscite law denied Davis, a United States citizen, the right to vote in the planned plebiscite election on account of his race. About 6 weeks ago in July, the Ninth Circuit issued its decision stating Guam's limitation on the right to vote in its political status plebiscite to native inhabitants of Guam violates the 15th Amendment. The Ninth Circuit made clear that the 15th Amendment prohibition on race-based restrictions is both fundamental and absolute. However, even while reaching this conclusion on the plebiscite, the Ninth Circuit took no position and stated it makes no judgment about Guam's targeted interests in the self-determination of its indigenous people. The court did not reject the stated purpose for holding the political status plebiscite, which was to allow a starting point for a process of self-determination. The process, not the purpose, was deemed unconstitutional. I think a lot of this has been glossed over, regardless of how you view the Ninth Circuit Davis opinion. I felt that something that came out of the opinion was that the Ninth Circuit never rejected that the people of Guam had the right to determine its self-determination, and we operate within the constitutional rules that apply to Guam as a U.S. territory, and the 15th Amendment is one of those constitutional mandates. And this was the result in reference to that particular holding. But I glean that what has been, I think, missed in a large part of the discussion, at least in what I've been reading, is that the process was rejected and not the ultimate purpose of the plebiscite law. The current administration has acknowledged the importance of the issue of self-determination for Guam. Just this past June, Lieutenant Governor Joshua Tenorio appeared before the United Nations Special Committee on Decolonization and urged the UN to enable a visiting mission to Guam to examine and record the situation to Guam. If indeed they came, what would they see? I believe that we can confidently say Guam has explored 3 political options. The purpose of the plebiscite at issue in the Davis case was the self-determination of Guam's indigenous people, and this remains an important issue for Guam. It follows then that Guam's political status remains a viable issue for discussion. The 3 political status options are, first, statehood. And statehood means full incorporation into the United States, with all the rights, privileges, and responsibilities of every other state in the Union. What would this mean for Guam? According to the Guam Statehood Task Force position paper, with statehood comes the ability to vote for the president and vice president, voting representatives in Congress, full protection of the United States Constitution, which celebrates its 232nd birthday in a couple of weeks, permanent citizenship, and a host of other benefits. Naturally, statehood also means the additional payment of federal taxes. And then we have free association. There are 3 examples Guam could look to as examples of a free association. The sovereign nations of the Republic of Palau, the Federated States of Micronesia, and the Republic of the Marshall Islands, established after the dissolution of the Trust Territory of the Pacific Islands. Each has negotiated an agreement, a compact of free association with the United States that defines the nature of their relationship. Similarly, if Guam chose this political status, then our relationship with the United States would be governed quite literally by the agreement negotiated with the United States. Notably, the Task Force on Free Association acknowledged that free association is not a permanent relationship with the United States, but a transitional status in which Guam, as an emerging sovereign state, develops and solidifies its political, cultural, and economic foundations to enable future generations to make the decision of whatever final political status they may decide. Therefore, it would only be a matter of time before Guam decided on statehood, which I discussed earlier, or independence. And then the third option, independence. This political status is arguably the most controversial because it has the greatest potential for change. Under independence, Guam would be in control of its land, its waters, its borders, and its international relations, including its relationship with the United States. The island could also structure its own system of government, one that may be structured differently from the United States model that has existed in Guam for over 120 years. Guam's government is modeled after the United States, 3 co-equal branches and a system of checks and balances. I cannot imagine this model would change if Guam pursued a status of free association with the United States or statehood. But would there be a change to the governmental model if Guam pursued the third status option? That is, if Guam decided to pursue independence. Guam's current framework began at the turn of the 19th century when Spain executed the Treaty of Paris in December 1898, ceding the island of Guam in the Marianas or Ladrones. Guam was first placed under the control of the Navy Department and the first naval governor of Guam, Captain Richard Leary, arrived at Apra Harbor on August 10, 1899. This iconic photo of President Harry S. Truman marks another historic moment for Guam, the enactment of the Organic Act of Guam in 1950. This federal law meant that Guam would no longer be administered by the Navy. The chief executive would no longer be a naval commander, but a civilian appointed by the United States President. Under the Organic Act, Guam elected the first Guam legislature. When the Organic Act was amended in 1968, one of the last vestiges of direct federal control in the administration of Guam, that of the appointed governor, fell away. The people of Guam could finally elect its own governor. Guam's judicial branch has also seen its share of struggles for independence. When enacted in 1950, the Organic Act of Guam authorized the creation of a local judicial system, but retained the authority of hearing appeals in the Federal District Court of Guam. Thus, when Guam established the first Supreme Court through the Court Reorganization Act of 1974, the U.S. Supreme Court struck down our court in Territory of Guam versus Olson. As a result, appeals from the decisions of the Guam local courts continued to be heard by federal judges in federal courts. The U.S. Supreme Court held that the text of the amendment of the Organic Act, which allowed the Guam legislature to determine the appellate jurisdiction of the district court, did not give it the authority to take away its appellate jurisdiction. And in a 5-4 decision, it held that the Guam legislature did not have that power to then create the Guam Supreme Court. It would take another 18 years in the passage of the Frank G. Lujan Memorial Court Reorganization Act by the 21st Guam legislature for the Supreme Court of Guam to be re-established. Even this step toward an independent judicial branch was subject to federal review. The Organic Act amendments required that rulings from the Guam Supreme Court of Guam be appealed first to the Ninth Circuit, an intermediate court of appeals normally reserved for appeals from the federal district courts, not state supreme courts. It was not until the 2004 amendments to the Organic Act that judicial authority was vested in a unified judicial system composed of the Supreme Court of Guam, the Superior Court of Guam, and other lower local courts. Today, the Supreme Court of Guam has full parity with the Supreme Courts of all 50 states. This means that decisions of the Supreme Court of Guam are reviewable only by the U.S. Supreme Court. From my perspective, this achievement cannot be understated. Now, to go back to the question I posed earlier, would there be a change to Guam's governmental framework if Guam chose to pursue independence? I'd like to focus specifically on the judicial branch, for which I admit I harbor a slight bias. In particular, I'd like to discuss this question: what might a judicial system look like in an independent Guam? In other words, if we had a clean slate and were crafting a constitution as an independent nation, how would we choose who gets to decide cases? I say this under several assumptions. First, the assumption that a court system will continue to exist in an independent Guam, because I assume the people of Guam would continue to have disputes needing resolution, disputes with families, between businesses, and between citizens and the government. I assume there would still be a need to protect the rights of the people and the rights of those charged with crimes. And finally, I assume that the current model of having a neutral judge to make these decisions would continue to be the primary method of resolving disputes. The cornerstone of most modern judicial systems is the principle of judicial independence. Let's start with what that means exactly. Judicial independence is a concept that the judiciary should be independent from the other branches of government. In other words, courts and the judges and justices who preside over them should not be subject to improper influence from the executive or legislative branches. It also means that the court should not be subject to improper influence from private or partisan interests. An independent judiciary, free of political influence or economic corruption, is universally recognized as essential to protect human rights and the due process of law. Most countries attempt to achieve judicial independence through their means of judicial selection. How they choose judges. Tonight, I'd like us to look at Guam's current judicial selection process and compare it to the range of models available both in the United States and in other parts of the world. Is there a better system out there that might be a model for the island under independence? In the United States, federal judges are selected by executive appointment. They are nominated by the president and must be confirmed by a majority of the Senate. Guam, along with a handful of states, has a similar appointment process. Judges are nominated by the governor and confirmed by the legislature. The minimum qualifications to become a justice of the Supreme Court of Guam are 1, United States citizenship, 2, bona fide residency in Guam for at least 5 years, and 3, active practice of law in Guam for at least 10 years before nomination. The requirements are the same for a judge of the Superior Court, with the exception that a nominee must have been in the active practice of law in Guam for 7 years before nomination. Now, some of you might be wondering how this selection process, where our judges are selected by politicians, promotes judicial independence. That is often the critique of this process. After all, wouldn't judges feel beholden to those who place them on the bench? Well, ideally, judicial nominees are selected because their competency, integrity, and loyalty to an oath of office are without reproach. The vetting process preceding legislative confirmation hearings helps to shed light on any questionable characteristics of a judicial nominee. If this checks and balances approach is not enough to ensure judicial independence, other safeguards such as life tenure or at least long tenure ideally frees judges to decide cases without fear of losing their seats on the bench over decisions opposed by political or economic interests. Life or long tenure also safeguards against concerns about post-judicial employment. Decision-making by judges with shorter terms may be influenced by the judge's need for future employment. Guam has a twist on life tenure. Judges and justices in Guam hold office virtually for life, but may be voted off the bench during a retention election. Guam law provides that every 7 years for judges of the Superior Court and every 10 years for justices of the Supreme Court, voters are asked whether or not a particular judicial officer should retain his or her seat. Retention is decided by a majority of those voting on the question. So far, no judge or justice in Guam has lost a retention vote. Interestingly, gubernatorial appointment is not the primary method of judicial selection in the United States. As I mentioned earlier, only a handful of states select judges via gubernatorial appointment: California, Maine, Massachusetts, and New Jersey. 2 states, South Carolina and Virginia, ask their legislatures to select judges. So in South Carolina, the assembly, the state legislature, are the ones who select the judges on the courts in South Carolina and Virginia. The remaining 44 states and the District of Columbia select judges in one of 2 ways: popular election and a method called assisted appointment. It may surprise you to learn that in nearly half of the states, judges are selected by voters in either partisan, meaning that the judge declares a political party affiliation as listed alongside their names in the ballot, or nonpartisan elections. As of 2013, 13 states elect their Supreme Court justices in nonpartisan elections, and 9 states use partisan elections, for a total of 22 states. That number increases significantly when looking at the selection method for lower courts, such as the state trial and intermediate appellate courts. While election by the people is seemingly the most democratic method of judicial selection, it has its fair share of criticism. One, the fear that by acting like politicians and seeking votes, and yes, in many places, judges campaign for election, judges use their credibility as neutral decision makers. Also, the need to raise money for elections can foster corruption and politicize candidates for judicial office. Another fear is that subjecting judges to popular election puts their decision making at risk of being influenced by popular opinion. In other words, the judges would decide cases based on how voters would in turn react to that decision at the voting booth. Former Supreme Court Justice Sandra Day O'Connor ardently opposed the practice of electing judges, referring to elected judges as politicians in robes, and stating no other nation in the world does that because they realize that you're not going to get fair and impartial judges that way. I actually went on the internet and I wanted to check the accuracy of Justice Sandra Day O'Connor, that no other nation in the world elects their judges, and I did find one, and that's the United States and Bolivia are the only nations that elect their judges. So we're on our own, really, in reference to electing judges. A third method of selection has developed in the United States as a sort of middle ground between gubernatorial appointment and popular vote. The assisted appointment method of judicial selection, sometimes referred to as merit selection or the Missouri Plan, is a process by which the governor appoints judges with the help from a commission or a board. This process usually involves a nominating commission comprised of both lawyers and non-lawyers chosen by the state bar and/or executive branch, which interviews and screens candidates for judicial office. The commission then sends a short list of qualified candidates, usually between 3 and 5 names, to the governor for consideration. The governor must select and nominate a candidate from the list. Some states then require additional confirmation from the legislature. Typically, after serving a specified initial term, a judge must go through a yes-no retention election, just like the retention elections held every 7 or 10 years for each judge and justice in Guam. Indeed, Guam's judicial selection process is often referred to as a modified Missouri Plan because of its use of retention elections. However, Guam does not have a judicial nominating commission. While the Guam Bar Association is asked to provide a list of qualified nominees for consideration by the governor, this is really merely a token gesture. The governor is not bound to nominate from the list. As of 2013, 22 states and the District of Columbia begin their judicial appointment process with some form of nominating commission. An additional 10 states use this process for interim judicial appointments. Retention votes are usually in the 60 to 80% range in favor of retention, but it is not unheard of for a judge to lose a retention election. The few judges who are not retained lost their election largely because of hot-button issues. For example, in 2010, the Iowa voters removed all 3 Supreme Court justices facing a retention vote that year after the court's unanimous but controversial decision to legalize same-sex marriage. It was the first time any Iowa justice had been removed by voters. Other judges have lost their seats after unpopular decisions concerning abortion and the death penalty. In the CNMI, a few years ago, we had a local female Superior Court judge who lost a retention election. She was the presiding judge in a very contentious divorce case. One of the parties in that divorce case was a local Chamorro woman, and she made it her vendetta to campaign against this local Superior Court female judge from Saipan, and that judge unfortunately lost the retention election because really it came down to one highly contested divorce case, and I felt that was unfortunate. But by far, judges are retained at high rates. So while retention elections have gained little traction outside the United States, using Judicial Nominating Commission has. In England, for example, dissatisfaction with the traditional system of judicial selection led to Parliament passing a comprehensive Constitutional Reform Act in 2005. The Act created the Judicial Appointments Commission, an independent, non-governmental institution charged with judicial selection. The Act also created a Judicial Appointments and Conduct Ombudsman responsible for handling complaints about the appointments process. The Act mandates that in selecting nominees for the bench, the Commission's decision must be based solely on merit with no other consideration other than an encouragement for diversity, subject to considerations of merit. The Lord Chancellor, a high-ranking member of the Cabinet responsible for the efficient functioning and independence of the courts, has the authority to appoint judges and may accept, reject, or require consideration of the Commission's nomination. Judges of the Supreme Court hold office during good behavior, meaning for life, subject to a mandatory retirement age of 70. So in England, we have a nominating commission in which the Lord Chancellor, this is a very high-ranking individual, actually gets to appoint the judges, and that person has to appoint from the list that is as provided, like some U.S. jurisdictions, where a governor is given a list from a nominating commission. Now, the Kingdom of Tonga, the only nation in the Pacific to have retained its monarchy, has only recently adopted the assisted appointment model. In 2006, thousands of Tongans demonstrated against the government and demanded democratic reforms. 2 years later, King George Palau V announced that he would relinquish much of his power and surrender his day-to-day role over the government. In 2010, significant amendments to the Constitution included the creation of the Judicial Appointments and Discipline Panel responsible for judicial nominations, judicial discipline, discipline of members of the judiciary for bad behavior, as well as the pay and terms of judicial officers. Judges are appointed by the king with the consent of the Privy Council, and that's the cabinet, after receiving advice from judicial appointments and discipline panel. And again in Tonga, judges hold office during good behavior, and there's no mandatory retirement age. I often wondered, and I checked the internet, and what would happen if the King of Tonga did not select from the list. I could not find the answer to that, and I think if you're king, you could probably get away with it, but I really don't know. Now, in the Republic of Palau, which is our neighboring island jurisdiction, in which Chief Justice Merriman sits on the Palau Supreme Court, a judicial nominating committee chaired by the Chief Justice of the Supreme Court and composed of members of the bar and non-lawyers appointed by the President screens and interview applicants and submits a short list of 7 names to the President. The President must appoint from the list, and judges in Palau serve for life. While assisted appointment seems to be the preferred method of judicial selection, it is not free of criticism. The main critique is that using nominating committees diminishes public and media interest in the process of selecting judges because of the appearance that an independent body is protecting the public's interests. The high rate in which judges succeed in retention elections may further demonstrate a lack of public interest on who is allowed to sit on the courts. This may be one reason that the U.S. federal selection model of presidential nomination and Senate confirmation, a system that seems at odds with notions of judicial independence, in practice has mostly proven to produce independent judges. The intense media and public scrutiny over the federal selection and appointment process enhances public awareness of the importance of judicial independence. And strong public interest in the process enhances the likelihood that only the most qualified and impartial candidates will be selected. At least we hope so. And we really saw an example of this with the recent nomination of Judge Kavanaugh, now Justice Kavanaugh, in the U.S. Supreme Court. The intense media attention, the process that he had to go through in the confirmation process, scholars said this gives a focus in making sure that this process of presidential nomination and senatorial confirmation, that we will get justices that hopefully will be fair and impartial and be governed by the rule of law. And so far, I think for the most part, we've seen that that is the case. Many other countries use an entirely different method of selecting judges. In the career or civil service systems, judges are selected through rigorous examinations and training programs. Emphasis is placed on judicial education even before starting a judicial service. In France, for example, potential judges must complete a bachelor in law and a master in law before entering the National School for the Judiciary, where French judges and prosecutors are trained. Admission to the school is made through highly competitive written and oral examinations. Selected candidates generally start a civil service career for life. After a rigorous 31-month course of study in both legal theory and legal practice, a series of examinations is used to rank students by order of merit, which determines in which courts they will commence their judicial careers. Promotions are determined by a judicial commission composed of judges and judicial administrators, and seniority plays a major role in promotions. So we see in France that it's a totally different way of selecting judges. Here you have career civil servants who actually are trained to be judges even before they get to the bench, and they're educated to become judges even before they get to the bench. This is the same in Japan. Japan uses a variation of the civil service model. Each year, approximately 20,000 law graduates take the entrance exam, but only 700 are accepted into a 2-year training program, followed by a 10-year probationary apprenticeship. The Supreme Court of Japan selects and promotes future judges. And while lower court judges cannot be removed unless deemed incompetent, the appointment of a Supreme Court justice is reviewed by voters in the first general election following their appointment, and justices are subject to retention elections every 10 years thereafter. So we see the model in France and in Japan. This is the civil service systems, and they are praised for providing equal access to the judicial profession through merit-based selection, training judges before they take the bench, and insulating judges from political influence. However, judges in these systems may be subjected to greater and possibly inappropriate influence from senior judges who control promotion with little transparency in those outside the courts. Now, I read an article of an incident where a junior liberal judge in Japan was presiding over a very high-profile case. It was a case where the government wanted to build a military building in a forested land area. And there were a lot of opposition to this government effort to try and build this building. And this junior judge, during the course of the proceeding, received a letter from a senior judge. And the bottom line is that if you know what's good for you and you know what's good for your career, you will decide in favor of the government. Well, this letter leaked out, and there was so much controversy. The Ethics Committee in Japan, part of the parliament, conducted a full investigation, and it turned out that the junior judge, after this full investigation, was reprimanded, and the senior judge who wrote the letter was completely cleared in this investigation. So this goes to show that you can have the best intentions, have a very expensive schooling, training, and leave it to the judges and the system of that judicial process to appoint and promote, but you're not going to be completely free of influence. And in this case, it's the system itself, the judicial officer, the senior judge who got away with this. And that's the criticism in these countries, in these areas, with this type of system, that senior judges have great influence on the assignments, who gets promoted, who gets accepted, and this is a major criticism. I read that a legal scholar summed up and observed this process and said that there is no plausible way of designing or structuring a court so as to insulate it entirely from political influence. Now, we hope that people in this room and the process, that should we have this opportunity, that we try to at least, as much as possible, protect against that. There are countless other judicial selection methods or variations of the methods already discussed, but we could be here all night and still only scratch the surface. I tried to touch upon and compare the United States system, where there really is 5 variations of selecting judicial officers. You have the gubernatorial appointment, you have the selection of judges through the legislature, you have popular elections where you have partisan elections, nonpartisan elections, and then you have the appointed commission type process, providing a list to the governor in which to appoint. And of course, there is much more to crafting a justice system than just looking at how judges are selected. For example, we might consider what role traditional methods, and I read this in one of the papers in the independent subcommittee's papers, of dispute resolution, such as the restorative justice principle of inaffa malik. This goes back along in our tradition in terms of even before how courts were established in the pre-Navy days and during the Spanish times, where we had our local culture where the elders really took care of meting out justice and resolving disputes. And should this play a role in our justice system? But then again, this would take much more than just the hour that we have been given to explore this, and certainly much more than my level of expertise. I hope that what I have been able to convey to you tonight is the process of selecting judges is a critical component to ensuring an independent judiciary. It's clear that there is no perfect system of judicial selection, but we can learn from the different experiences both within the United States and throughout the world. To decide what might work best if we designed a system as an independent nation, with our highest court having the final say on issues that come before it. Would an independent Guam want to directly elect its judges, or perhaps follow an assisted appointment model and create a judicial nominating commission? If we did, who would get to choose the members of the commission? We might even conclude that our current selection method works just fine. You know the old adage that if it ain't broke, don't fix it. In any case, I hope this will foster good discussion about tailoring a judicial system that promotes judicial independence. For history tells us that the overall success of a nation depends upon public confidence that court decisions are based on the rule of law rather than the rule of a select few. Thank you for your attention. Now, we do have some time for some questions. Do you have any questions? I really just wanted to try and generate some thought that if we did decide as a people to elect the status of independence, that we would really have a clean slate in which to come up with a judicial structure. We really would be dependent on how we select our judges. I think that's the point that I'm trying to make. There are, of course, all other issues relating to this, but that's the core, the fundamental in reference of organizing a judicial branch. And I've really just offered some models and mentioned the career civil service type system because we don't have that in the United States. That exists in other, and you see the European and countries like England and Japan. Germany and Italy has the same thing. Now China, that's just a completely different system. On paper, it really looks great. When you do the research, you look at the structure, you look at their constitution. On paper, they are a independent, well-oiled type judicial system. But I really suspect that that's the case. I think the Communist Party has a very predominant control over how the judicial system operates, and that's not. I also, took a very quick look at Russia. I mean, can you imagine, the judiciary voting against Vladimir Putin, President Putin? Where would they be the day after? And so you can have the best system on paper, but in practice and actuality, it may be another thing. Anyway, I just wanted to offer some thoughts that you may want to consider.
Any questions?
Any questions? Is that Doris? Yes, Doris.
Thank you, Justice Carbullido, for a very informative presentation. As you mentioned at the end, no one system is perfect. They all have their pros and cons. I just want to pose one question to add to the mix of the discussion. And this question really came out yesterday when I was listening to the Jim Bohannon show on the radio. And the question he posed was, should there be an age limit to the presidency? And so, as we know, for example, Justices once they're appointed, are, as you had mentioned, almost there for life. So my question in this mix of discussion, and for regardless of what status we choose, should an age limit be considered?
In most jurisdictions, there is an age limit, and it's usually between, at least in the United States, 70 to 75. There's been much writing that because of the longevity now of modern lives and people that still have a very sharp minds at a later age, that maybe this is something that we can increase to age 80. But it's really only the federal system and some state systems that have life tenure, that we have that in the federal courts in terms of life tenure. But for the most part, in the state systems, there is a mandatory age requirement. In the Philippines, there is, and you've seen recently just a constant turnover of the chief justices in the Philippines because of the mandatory age retirement of age 70. So for the most part, there is an age, retirement age.
Would you advocate it?
I'm 66. And I still enjoy very much what I do. But yeah, but you know, I mean, if you're not doing your job, the people of Guam, under our system, the retention election, can vote you out. And so if there is going to be an age requirement, I think 75 is a reasonable age requirement. And so I would not be opposed to something like that. Yes.
Hi, Your Honor. I think I came here, one of the primary reasons was to get some maybe historical reference to the Chamorro judicial system, if it existed prior to colonization. If any, if you were able to look into that, or if it exists, and sort of how, if any, it could be adapted to Western European usages already. I think, you know, this presentation has definitely given us a primer on how people in the US do it, and we touched a little bit on Tonga and Palau, but what, if any, Chamorro judicial ways from the past can be adapted to currently? So, for example, I don't know if we had judges in each village. Is that something that we can imagine? What can we do that's different, that's actually authentically Chamorro moving forward in an independent governance? Well, not governance, let's speak specifically to the judiciary. Is there something that you imagined that would be different from what we have now?
Yeah, what I read, and there is limited material on this, but I did read, and that's why I mentioned restorative justice, inafa malik, respect, because prior, as I understand it, to the court system being established, our ancestors, you know, handled differences by their elders. The elders, for the most part, in the various jurisdictions, and there, you know, Hope Cristobal is here, there's BJ's here, there's people in the room that can speak to this a lot better than I can. But from my limited reading, there, a large part of that was relied upon in reference to resolving the differences by elders in the community in kind of like a mediation type process. And you know, before we had the organized court structure, this seemingly was a practice, you know, during the Spanish times.
In your experience, do you think it would be viable to have a judge say, this is just hypothetically because I feel like, you know, Chamorros and people, non-Chamorros and people here, we want to stretch our imagination toward the future and sort of remember who we are. Do you think that it's viable to have, say, a judge at a trial level in each village, and then maybe an appellate sort of system that we create, and then a Chamorro, or not a Chamorro, maybe a Chamorro, that would be amazing. But an independent Guaman Supreme Court? You know what I'm saying? Like, how do you think that would be a viable option?
Well, you know, we live in times where disputes have to be resolved in a fair and impartial way. We have methods to try and seek resolution outside of the traditional court structure, mediation, arbitration, settlements. And so those are viable options and alternatives. And whether or not that can be relied upon totally to resolve modern differences in reference to the economy, business disputes, contracts, differences, I think it can be helpful to supplement our modern way of resolving differences. And keep in mind that the characteristics that, in my mind, that should be taken into account in founding and establishing any judicial system is, as I mentioned, you want it to be independent. You want it to be fair and impartial in terms of a judicial officer, that you have your day in court. And you want it to be accountable. And you want a judicial structure that is accountable to the people, not determinative, because you always want the rule of law. What is the law and the facts, and not the popular opinion to determine the outcome? Because once you get into the way of thinking that what is most popular is probably a better way of resolving, there are so many abstracts in terms of being tripped up in that way.
Okay, last one. Would you be willing to serve as an elder instead of a judge under an independent Guaman judiciary?
I'm 66 years old. I'm well on my way. My wife will attest to that.
Hi, Your Honor. This one's short, but
Is that Siobhan back there?
yes, it is. Hi, Phil. But I mean, Your Honor.
Be nice. Okay.
I was going off of your question because I'm glad you brought that up. But I know in Palau they have the House of Traditional Leaders, and I was thinking how viable that would be for a potential independent Guaman to have a House of Traditional Leaders that kind of works in partner with the governmental system. It's complementary, but there's also like a clear protocol that's designed to kind of implement the cultural customs in Palau into the more formal system that they have now. So kind of, I guess what that would look like on Guam, if you've thought of that when you were doing your research on the judicial systems in Palau. And yeah, and I guess specifically regionally, I know you talked a little bit about their systems, but were there any other islands too that we can learn from moving forward?
Well, I think, you know, the practice in Palau in terms of our traditional leaders, I don't know much about it, but I recall that when I was in American Samoa and I was talking with a Samoan judge from Western Samoa, you know, still very much part of their culture and tradition is resolving differences outside the court system. And these can be very serious offenses, not just, you know, your really small infractions. And I think I understood it to mean that these serious offenses can be actually handled between families and differences resolved. I was actually quite surprised at the type of crime that was being referred to and resolved outside the court system. And I don't know if that still exists today, but this was a discussion that I probably had, you know, within the last 10 years.
Hafide, have you given any thought to who would be allowed to practice law under an independent Guam?
I would think that if we, you know, although an independent Guam, if we decide that the model is an independent republic and not within the United States model, that, you know, this can be something totally open for discussion. But I think there needs to be standards, controls, because ultimately, you're doing this for the people of Guam. You want to make sure that the standards that are going to be utilized to assist them in making a better way of life for themselves, in making sure that they're adequately represented and given a fair and impartial, you need to have standards. And I still think that if that's the case, you need to have licensed lawyers, because lawyers are licensed for a reason. They're licensed to protect the public, not necessarily so that they can receive a certificate and so they could go make money. They're licensed and regulated to protect the public, and that involves ethics and just the standards in terms of the competence. And so I would think, that's what the people of Guam would continue to want, regardless of the status of government. Yes, Mr. Palau.
I have a question for you. I was reading some research recently that Western democracies are exceedingly failing and becoming more authoritarian. So if Guam or any other country at that would decide to become independent and choose a form of government, I don't think it can necessarily be assumed over the long run that this would necessarily be a Republican democracy like we've seen previously or would exist that way. What do you think, though, in envisioning a judiciary maybe outside of a democratic government, what thing that you've talked about would be most important in ensuring a independent judiciary, regardless of whether we have a democratic or other type of government?
And that's why my central theme is, no matter what form of government you have, in the establishment of a judicial branch of government, judicial independence is first and foremost important in reference to, in my mind, in creating a judiciary. That is the central theme in which everything is built around, and that's been my experience and what I want to continue to see in reference to all my efforts, our efforts in terms of my colleagues on the judicial branch. And that's the main characteristic that I see that we have to center around in reference. We speak of in the United States system as a third co-equal branch of government that provides checks and balances. And quite frankly, I have not seen, read, or heard of a structure that is better suited to protect the people. And that's ultimately the system that I think everyone in this room would want, regardless of the form of government. Carla?
Yes, Chairman. So I was wondering if you have given credence to recent theories on departmentalism and the idea that branches of government, that the other two branches are co-equal to the judiciary in interpreting the Constitution. I'm wondering if in an independent Guam, you would import our notions of judicial supremacy in interpreting what presumably would be a constitution that we would convene.
I don't think that the judicial branch anyone will benefit to having a third branch of government being superior in reference to any interpretation of the Constitution. It goes back to Marbury versus Madison. The judiciary, are vested with the responsibility to interpret what our lawmakers enact. And we don't take it upon ourselves to judicially create the laws. And I say that our proper role would continue to be a branch of government that would interpret the law, enforce the law, and do it in a fair and impartial way. And so I may be missing your point, but I don't see this as the opportunity to create a super branch of government so to speak. I don't know if that's necessarily a fair characterization of what you asked, but I still don't see a better model. Thank you for your time.
I'd like to announce that next month, Phil Flores will be our guest speaker, and Phil will be speaking about banking and business in an independent Guam. So we have a series that's coming up. Lee Weber will come in November, and he will speak about the independence of the fourth estate, and that is the media under an independent Guam. And in December, Jerry Perez will be talking about independence, the price, and its effect on tourism. So come back. Thank you for attending.